Good morning, class. This is Attorney Season, and today I'll be discussing arrest and its technicalities. So, presentation outline. Number one, we have the general guidelines in making an arrest. Second, authority of the arresting officer when making an arrest. Third, duties of an arresting officer. Fourth, arrest with warrant. And lastly, arrest without warrant. Okay? So number one, the general guidelines in making an arrest. So when is arrest allowed? So all arrests should be made only on the basis of a valid warrant of arrest. And who issues a valid warrant of arrest? It is the judge. Okay? So issued by a judge. Except in instances where the law allows warrantless arrest. So kanus man gaalaw ang law o warrantless arrest or lawful warrantless arrest. So we have the three exceptions. Number one, in flagrante delicto or caught in the act. Second, hot pursuit. And third, escapees. Okay? So the doctrine is that a warrant of arrest is required before an arrest is made. That's the general rule. And the exception is that is the warrantless arrest. The three exceptions. Okay? So, in flagrante delicto again, or caught in the act, hot pursuit, or escapees. Okay? Muna siya tulo ka exceptions. What is arrest? So, an arrest is the taking of a person into custody in order that he may be bound to answer for the commission of an offense. So, it doesn't mean that a person being arrested is already guilty. Okay? Because the purpose of arrest under Section 1, Rule 113 of the Rules of Court is only the taking of the person into custody in order to be bound to answer for the commission of an offense. And also, the person arrested is presumed innocent until proven guilty by the court. So it is only the judge who can determine whether a person is guilty or not guilty. So if na maganit tayo makita nga gi-aresto, it doesn't mean that he is guilty of the crime, okay, that he committed daw, okay. However, he is entitled to a defense, due process of law, okay. He is presumed innocent, okay. That's why we have the so-called presumption of innocence under the 1987 Philippine Constitution. And it is only the judge who can determine whether a person is guilty or not guilty, okay. So what is a warrant of arrest? So a warrant of arrest is a written document issued by a court ordering any law enforcer to bring the person, okay, before the court so that he may be bound to answer for the commission of the offense. So this is an example of a warrant of arrest, okay. So this warrant of arrest is for Vong Navarro, okay. So this is the example, this is the format of a warrant of arrest for a rape case against Mr. Bong Navarro. So to any officer of the law, you are hereby commanded to arrest Bong Navarro, who is said to be found at Monticello and Onglaco law offices, okay, etc. address. Then the bail for the release of the accused in this case is fixed at non-bailable because this is a rape case. That's why Bong Navarro must file a petition for bail to prove that ang evidence sa prosecution is not strong. Okay? Because if you can prove that the evidence of the prosecution is not strong, then he can definitely, or Bong Navarro can definitely bail. Okay? Bail out. Okay? So that's why mag-hearing pa, that's why mag-file ka petition to bail. Okay? So mag-hearing pa whether or not strong ba ang evidence sa prosecution. Because if not, grantan og bail si Bong Navarro. Okay? So very important is the third paragraph. Okay? So whenever you will effect warrant, whenever you will execute a warrant of arrest or a search warrant, you are now required to use at least body-worn camera, the BCW, and one alternative recording device such as your cell phone, as long as yung battery lifespan is over 8 hours, or a minimum of 2 devices, or such a number as may be necessary to capture and record the relevant incidents in the execution of the said warrant of arrest. Okay? This is pursuant to the rules on the use of body-worn cameras in the execution of warrants, either search warrant or warrant of arrest. Okay? Don't worry. I will provide a separate pre-recorded video lectures about the use of body-worn cameras in the execution of arrest. Okay? So this is an example of a warrant of arrest. What are the requisites for a valid warrant of arrest? So, number 1, it must be issued upon probable cause. Okay? Dapat na ay evidence, there should be a probability. Okay? That's why i-determine, i-judge. That's the judicial determination of probable cause for the issuance of a warrant of arrest or a search warrant. Dapat na ay probability that an offense has been committed by the respondent or by the soon-to-be accused. Okay? And that the person, okay, is probably guilty thereof if he committed the crime. Okay? So only probability, not proof of guilt beyond reasonable doubt. Because if dapat proof of guilt beyond reasonable doubt, so what's the purpose of the trial? Diba? Because na ay trial in order to determine whether a person is guilty or not guilty. So in order to prove that a person is guilty, dapat makonvict siya, proof of guilt beyond reasonable doubt. So that's why in the issuance of a valid warrant of arrest, probable cause only, meaning probability lang ba that an offense has been committed by the person sought to be arrested. Okay? So not not proof of guilt beyond reasonable doubt. Only probability. So mga evidences lang. Okay, nga mag-prove nga si accused good ang nakakommit sa crime. Maybe CCTV footages, affidavits of witnesses, etc. Okay? Nga mag-prove nga na-agree probable cause nga si person to be arrested has committed a crime. The existence of probable cause is determined by whom? By the judge. It is only the judge who can determine the existence of probable cause. Therefore, third, the judge must examine under oath the complainant, okay, and the witnesses of the complainant. So that's why, di ba, mo file tag, complaint, affidavits of witnesses. So katong mga ni-file o complaint o katong affidavit of witnesses, ni-file ato mga witnesses. That's why i-examine to ni judge under oath. Okay? And then, oh yes, the difference between, what is oath? So you take an oath when you believe in God, and you take an affirmation when you don't believe in God. So that's the difference between oath and affirmation. Oath, you believe in God, take an oath ka. Affirmation, if you don't believe in God. Okay? So yan na siya. And the warrant must particularly describe the place to be searched. So in cases for the issuance of a search warrant, dapat you particularly describe the place to be searched. Like as yung address, so complete address, block number, etc. Okay, dapat i-particularly describe the place to be searched. Dapat dili siya mo fall into a general search warrant because that is not allowed. Okay, general search warrants are not allowed. And also, and the person or things to be seized, the person to be arrested should be particularly described. Name, okay, age, gender, address, etc. Dapat i-describe yun mo. What is probable cause for the issuance of a warrant of arrest? So probable cause refers to such facts and circumstances which would lead a reasonably discreet and prudent man to believe that an offense has been committed by the person sought to be arrested. So, kato akong i-explain ganiya. It's about evidence lang as to the facts or circumstances which will lead a reasonably discreet and prudent man to believe that an offense has been committed. So maybe mga testimony sa complainant or testimonies of witnesses. Okay? Mayana lang. It doesn't necessarily mean nga dapat i-prove guni mo nga siya gyud ang nag-commit sa crime. Okay? Dapat proof beyond reasonable doubt na. No, that's why naatay trial. Okay, muna yung purpose sa trial. To prove the guilt of the accused beyond reasonable doubt. So, ang bulong ra sa issuance of the warrant is probable cause. Probability lang ba nga katong persons na to be arrested committed the crime. Okay? So, may mga types of evidences. So, kato, testimonial evidence. Testimony from the accused and his witnesses. Testimony from the complainant and his witnesses, and also mga CCTV footages, mga yana, etc. Documentary evidence nimo, mga yana. Okay? Under what instance shall a court issue a warrant of arrest? So, number 1, when there is a criminal complaint or information filed in court against a person. So, if nanay information sa court, mag-determine na si judge whether or not there's probable cause nga ang person sa to be arrested has committed a crime. So after evaluating all the evidence, if he finds probable cause, probability lang that an offense has been committed by the person to be arrested. So, and dapat i-place ang person under immediate custody so as not frustrate the ends of justice. Dira na mo issue o warrant of arrest sa judge. Okay? So, very basic. So, this is the case law that leads to the issuance of a warrant of arrest. So, A kills B. Okay? So, Mr. A went into hiding, katago. After a week, the police files a complaint for murder against A in the prosecutor's office. So, usually, ang i-file ani is complaint affidavit and affidavit of witnesses, mga evidences, etc. Okay? Mga murder weapon, ayan na, in the prosecutor's office. And then, after i-determine ni prosecutor if na ba probable cause. If makadetermine si prosecutor o probable cause, so this is called the executive determination of probable cause. During preliminary investigation, ang tawagan na is executive determination of probable cause. And if moabot na ganit sa court pillar katong probable cause for the issuance of a warrant, that's what you call judicial determination of probable cause. So let's go back. So muna siya gitawag nga PI, preliminary investigation, kaning second. Okay, this one. So ang sumofile si police complaint affidavit and affidavit of witnesses. Ano yung mga evidence i-file? And then, of course, i-subpoena ni prosecutor si accused, si Mr. A. Okay, subpoena meaning doon siya sa court, tatagan siya 10 days to file a counter affidavit or affidavit of his witnesses. So if dili niya maka-file o counter affidavit niya o iyang affidavit of witnesses, then of course, proceed si prosecutor o finding probable cause based sa complaint affidavit and affidavit of witnesses sa complainant. So if he can determine probable cause, so that's why mo issue siya resolution and information. Okay? And then, yan ang information, i-file na niya sa court. Okay? The prosecutor files the case in court, meaning information. Okay? So, pag nasa court pillar na information, i-determine dyan po na ni judge so nabugoy probable cause nga the person sought to be arrested has actually committed a crime. Okay? Probability only. The probability that an offense has been committed by the person sought to be arrested. Okay? So, if makakuha siya probable cause, therefore, may issue siya warrant of arrest. Okay? So that's the case law that leads to the issuance of a warrant of arrest. Who may determine probable cause for the purpose of issuing a warrant, either a search warrant or warrant of arrest? Answer is only a judge. Okay? Execution of warrant. So let's just say nanay warrant. So ipadala ng warrant of arrest dito sa warrant section sa police station. So the head of office or the head sa police station whom the warrant of arrest was delivered for execution shall cause the warrant to be executed within 10 days from its receipt. Okay? And within 10 days after expiration of the period, the officer to whom it was assigned for execution shall make a report to the judge who issued the warrant. So, mo-file siya return. Okay? And then, in case of the failure to execute the warrant, state dito o say reasons nga nung wala na execute ang warrant. Maybe wala na si accused dere, wala na nakitaan, etc. Okay? So, receipt of the warrant. So, from the court pillar, silibay na dito sa police station, sa warrant section, and then i-assign tong warrant, mag-assign tong head of office o kinsa mag-execute itong warrant. Okay? So, receipt of warrant. So, move on. Execute the warrant of arrest within 10 days. Okay? So, within 10 days from the receipt of the warrant of arrest. And then, after that, 10 days na po to make a report to the judge who issued the warrant. Make a report. Either na-effect na nimo ang arrest, na-serve na nimo ang warrant of arrest, nanas imong jurisdiction, na-arresto na nimo ang person, and or wala nimo na-execute ang warrant. Imong state imong reasons ra. So that's a report. What is the lifetime of a warrant of arrest? Is it 10 days, 20 days, or lifetime? So, a warrant of arrest, even if not served within the statutory period, remains valid unless recalled by the issuing court. Okay, so general rule, it has no lifetime. This is general rule. It can only expire when it is recalled by the issuing court or if the accused was arrested na or voluntarily submitted himself to the jurisdiction of the issuing court, meaning ni surrender, voluntary surrender, na arrest or nag-voluntary surrender. Unlike a search warrant which has a lifetime only of 10 days. 10 days ra gyud ang search warrant. After 10 days, ma-expire gyud, mo-apply na pug kag bag-ong search warrant. Okay? So that's the difference between warrant of arrest and search warrant. Warrant of arrest, unlimited. It has no lifetime. It ma-expire na siya when it is recalled by the court, okay, or the issuing judge, and or if the accused is arrested or voluntarily surrendered. Okay? Search warrant, 10 days only. After that, apply kay gusod. So what is the lifetime again of a warrant of arrest? According to Malaluan versus CA, no period is provided for the enforceability of warrants of arrest. And although within 10 days from the delivery of the warrant of arrest for execution, a return thereon must be made to the issuing judge. Diba? May example, execution of the warrant. So taga nag 10 days, after 10 days, taga na pug 10 days para mo-make og report. So said warrant does not become functus officio. Does not become functus officio, meaning having fulfilled the function or discharged the office, and therefore no further force or authority. But enforceable ra gyapon siya indefinitely unless the same is enforced, meaning na ka-effect na kag-arrest or nag-voluntary surrender si accused or gi-recall na siya sa court, okay, sa issuing court or judge. Okay? So to validly effect arrest, must the peace officer have in his possession the warrant of arrest? Rule 113, Section 7, the rules of court. No. The police officers may effect arrest without the warrant in their possession at the time of the arrest. But after the arrest, the person arrested may request to see the warrant, and that shall be shown to him as soon as possible. So, dili good required nga magdala-dala ang police officer og warrant of arrest. Okay? But definitely after arrest, the person arrested has the right to request to see the warrant, and you, the police officer, the arresting officer, shall show to him as soon as possible the warrant of arrest. Okay, so that's the purpose of Rule 113, Section 7. What are the instances where the law allows warrantless arrest? So a peace officer or a private person or police officer or a private person may, without a warrant, arrest a person when, number one, in flagrante delicto arrest or caught in the act arrest. So when the person to be arrested has committed, is actually committing, or is about to commit an offense in the presence of the arresting officer or the private person. So this is what you call in flagrante delicto arrest. So example, let's just say si Mr. A, police officer or private person, and in his presence, so Mr. B stabs C. Okay? So Mr. B has committed the crime now. Yeah, B stabs C, hit-an. Nagitan sa police. Nga si B yung stab si C. So, the person to be arrested or B has committed a crime na or has committed an offense na. And another example, A, in his presence, sees B stabbing. Stabbing, meaning actually committing na. Okay, the person to be arrested is actually committing the offense. Okay, therefore, pwede niya arrestuhan si B. Pwede si A, pwede arrestuhan ni A si B. Okay? Or third example, sees B, A sees B attempting to stab C. Attempting ha? So, is about to commit an offense. Therefore, pwede arrestuhan by virtue of in flagrante delicto arrest. Okay? So, in the example given, A may arrest B even without a warrant of arrest. Why? In flagrante delicto man. So, in my first example, so B stabs C. So, si B has committed a crime. Sees B stabbing C. So, B is actually committing a crime. Third example, sees B attempting to stab C. So B is about to commit a crime. Okay? So A may arrest B even without a valid warrant of arrest. Okay. Next, what are the instances where the law allows warrantless arrest? So when an offense has in fact just been committed and the arresting officer has personal knowledge of facts indicating that the person to be arrested has committed it. So this pertains to doctrine of hot pursuit. Okay? So as long as a personal knowledge of facts indicating the person to be arrested has committed it, the police officer can effect arrest. So example A, the policeman arrested A 2 hours after A had killed B. 2 hours after A had killed B. The policeman saw B dead in the hospital. So kabalo siya nga si B namatay jud. And when he inspected the crime scene, he found a piece of wood which A had used to kill B. So kita siya atong wood nga naidugo pa jud. So mo jud gigamit sa pagpatay ni B. Okay? And also napad eyewitness si Mr. D nga ni-report sa killing to the said policeman and pinpointed Mr. A as the killer. Now here in the example, the policeman did not need to actually witness the commission of the crime, but he has direct knowledge. Nano siya direct knowledge or personal knowledge or a view of the crime right after its commission, enough to create what? Probable cause in his mind that the person to be arrested has committed it. Why? Kita siya nga B. Kita siya sa dead body ni B sa hospital. Kita siya sa murder weapon. Napadyo'y eyewitness. So, miskan pag wala siya nakakita nga si A nag-commit og crime, killing B, but because of those circumstances, facts and circumstances, na siya personal knowledge. Okay? Or na siya view of the crime which would create probable cause in his mind that Mr. A, the person to be arrested, has committed a crime. Therefore, he can arrest A by virtue of the doctrine of hot pursuit. Another example, The policeman, based merely on a tip lang, given by a bystander that B allegedly stabbed C, proceeded to immediately arrest B, who altogether with his wife was about to go inside his house. So here, according to the Supreme Court, a hearsay tip pragani by itself does not justify a warrantless arrest. Why? Wala personal knowledge si police officer. Tip lang nga si A daw nag-stab ni that nga si B daw allegedly stab C. Wala gani siya kita ni C nga nadunggaban, wala siya kita sa murder weapon, etc. Okay? So wala personal knowledge si police officer nga na-commit jud ang crime. Okay? So it is a well-settled rule under the hot pursuit doctrine that the police officer must have personal knowledge of facts based on his observation that the person to be arrested has just committed a crime. Okay? And this is what gives rise to probable cause that would justify a hot pursuit. And as a rule, a hearsay tip by itself does not justify a warrantless arrest. Okay? You should take note of that. Another example, the killing of A by B happened on August 17 on the basis of the supposed identification of the two witnesses. So na duha ka witnesses nga naigipatay. Okay? And the police arrested B 5 days after the commission of the crime. Valid pa ba ang hot pursuit ani without a warrant? Gi-arrest si B 5 days after the commission of the crime. So no, the arrest is not valid. The warrant of arrest was declared illegal because even if we assume that the two witnesses had personal knowledge of the crime, it can no longer be said that the crime has just been committed. In order, according to the Supreme Court, kanang term nga has just been committed, meaning dapat within the day, kani 5 days naman nilapse. So proper procedure ta, dapat mo file og complaint, affidavit of witnesses, PI. Okay, dapat na preliminary investigation to determine probable cause. So isubpoena tong suspect. After that, ay itong respondent na kay sa prosecution pillar na, so respondent. And then hulaton iyang counter affidavit o affidavit of witnesses niya. And then determination of probable cause. Maka-determine of probable cause si prosecutor, issue siya resolution and information. Tapos isangat dayon sa court pillar. Then si judge, mo-determine siya o nabagay probable cause. If yes, mo kuan siya warrant of arrest. So in this case, dili na has just been committed ang crime. 5 days have lapsed already. Okay, dapat within the day, dapat August 17 gyud gi-aresto ang tao within the day. Okay? So third, of course, mga escapees. You can arrest an escapee if you're a police officer without a warrant. Okay? So when the person to be arrested is a prisoner who has escaped from a penal establishment or place where he is serving final judgment or temporarily confined while his case is pending, or has escaped while being transferred from one confinement to another, escapee. So valid warrantless arrest.